crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome in to the attorneys. Thank you so much for joining us tonight. Our topic of conversation has to do with something that really is relevant to where we all and kind of the crazy world that we're all living in right now. A little more on that on the way. First, I want to let you know how you could join our conversation because we'd love for you to do so. At the bottom of your screen, there's ways you can do that. Just follow along, call, text, email. We really try to make it easy for you. Also, Hollis Wright makes available attorneys who are standing by live for a free off-air and confidential conversation. The number to know there, and really the number to know any time, all the time, 24/7, 844-LAW-TALK, 844-LAW-TALK will get you to Hollis Wright during the show or even after the show. And kind of a neat opportunity there to speak with an actual attorney. Leading our conversation, he's the managing partner of Hollis Wright. Josh Wright, good to see you, sir. You doing okay?
I'm doing great. Hope you're doing great, too.
I am. Thank you.
So, your intro was perfect. During these crazy times that we're in right now, consumer bankruptcy is going to be up.
Right.
And so we decided we're bringing an expert on to talk about that. And there are a lot of opportunities other than actually filing bankruptcy, short of that people can use to manage themselves financially. To maybe keep themselves out of it. And so we brought an expert on, Josh O'Neill, today, and we're so excited to have him on because this is a relevant, pertinent topic and one that is completely outside of your skill set and my skill set, but within his. So first of all, welcome, and we're glad to have you on.
Glad to be with you guys.
So
today.
Josh, talk to us a little bit, tell us a little bit about your firm and how you got into this area of the law.
Well, we've been in practice for about 10 years now, and we have an office in Coleman, an office in Huntsville. And, it was actually a class I took in law school that I really enjoyed, and had some friends who were already with bankruptcy firms in that area, and so it was just a natural fit for us. And there was a need in that area, and surely there'll be a need, as you guys were talking about with everything that's going on in our country, there'll be a need for this, coming out of this pandemic.
Do you find yourself at times almost serving initially in a counseling role?
Absolutely.
To help counsel somebody through this? Because I know there are a lot of times you probably say, hey, look, bankruptcy is not your option right now.
Sure.
Here's what we can do to restructure what you're doing. Sure. And so I find that interesting because when you look at what a counselor is, a lawyer, an attorney, it is to counsel, and sometimes you've got to do that in this area of the law.
You really do because, some people may not know all their options. They may not know mortgage hardship opportunities. They may not know things they can do with some of their creditors to negotiate, and they may not totally understand the process, the pros and cons of filing, because in some cases it is by far your best options, and like you said, in some cases it's not your best option. And we try to be upfront with people and help them figure out what's best for their situation, not necessarily just, stick them in some cookie-cutter plan.
Can I ask both of you guys, can we bust a myth or a potential myth right here? Because I think that a myth in the general public is that lawyers are just ready to sue. Like, any case, so like if someone coming to you, like the perception is that you're going to want everybody to file bankruptcy. It's better for you. Folks coming to you with a car accident case, you're going to jump on every one because it's better for you. Is that necessarily the case? And can the both of you, how can you give that objective advice whenever suing and moving forward with the case is not the best
Josh,
idea?
I'll let you go first because I can handle it on the civil side too.
Sure, and I would say this is if you're an attorney, you're in a people business. You're in a relationship with people business, because I'm sure you would say that's where most of your clients come from, is your relationships with people. And the same with me and former clients is one of the things I always appreciate is they'll say, you represented my cousin, my sister, my sister's roommate, and you didn't really tell her what she wanted to hear, but she realized you were honest with her. Yeah. And you may be in a situation where you think, okay, I may make an extra $1 today, it's in my pocket, because these cases are how we make money, but you can ruin your reputation and your ability to deal with these people is far more valuable than this specific case.
Yeah, that's a great way to look at it too. I look at it real similar, that it is a relationship-driven business. But the number of times that someone comes to me with a potential civil case, whether it's an industrial accident or an automobile accident or whatever it may be, the number of times when I have to tell someone, hey, look, we've evaluated this, but you don't have a cause of action under Alabama law, and I'm sorry to tell you that, but you don't. People are frustrated with that, but you know what? They respect you, and they'll sometimes come back to you because they're like, man, that guy was really honest with me. We have another principle that Josh probably also has at his firm, which is we return every call, text, and email. So if someone emails me, they call me, they're going to get a response. And it's not just me, that comes from the top down, right? So I manage the firm, but all of our lawyers do that. It's really difficult to get frustrated and angry with your lawyer if he's honest and he communicates with you and he gives you honest advice. Really difficult to get really fired up with that person to say, well, I don't trust that. People want to not trust someone to say, I'm getting rid of that lawyer. When they trust you and recognize you're going to give them honest advice, they're going to consistently come back to you. So that's one thing that I found too. All right, Josh, so on this issue, one of the questions I know that we will get is, can I keep my property if I file bankruptcy? That's an issue that kind of always comes up. People are worried about their home and whether they're going to lose it. And so maybe kind of let's address that.
Well, absolutely you can. Some people do have the opinion that it's a myth, and sometimes it comes from your creditors that if you file bankruptcy, you have to give up everything and you start over with just the clothes on your back, and that's not true. Depending on your situation, the bankruptcy court does allow you to keep your property. It does allow you to keep your assets, things that you're paying on. You can keep your car, you can keep your house. Bankruptcy just allows you to sometimes restructure those debts, and so that you're able to keep those and some of your unsecured debts, credit cards, different things, things like that may have arose because your company was on shutdown or you were on a quarantine and you couldn't work and you ran up credit card expenses. Bankruptcy can help you with those things.
What is when we talk about the types of consumer bankruptcies,
yes,
Chapter 7, Chapter 13, can you just kind of give us a breakdown of those two?
Sure. A Chapter 7 bankruptcy there's asset limits that the court says, the basic two key phrases I guess you say is assets and income. For your assets is, do I have lots of equity? Because if you have lots of equity, there's the thing that the bankruptcy court considers, it's called the best interest of the creditors test. And basically what that says is, if I sold everything I had, this is all my creditors would get. And if it's a small amount of money, then that's where you would look at a Chapter 13 to say, I'm going to, keep my property. There's $10,000 worth of equity in it, so I'm going to pay my unsecured creditors $10,000 because that's all you would get if I sold everything. And if the bankruptcy court allows you exemptions in this, so sometimes you can still file a Chapter 7 where you just discharge your unsecured debts and keep your secured debts.
All right, when we come back, we're going to unwrap that a little bit more. I know we're getting ready to go to break, but there's so many issues here that are probably myths that we're going to be able to dispel tonight by simply getting Josh to answer.
We'll look forward to that. All right, we're stepping aside Josh and Josh on the show tonight. I should be able to remember y'all's names, I think, at this point. Stay tuned. We've got more of the attorneys with the Joshes coming right back.
I'm Josh Wright with the law firm of Hollis, Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
We love helping people. I think everyone at this firm feels the exact same way, that the reason we do what we do is to help people. And this show gives us the biggest platform possible to help as many people as we can in the community.
Welcome back into the attorneys. Hey, if you want to take advantage of the opportunity to speak with attorneys from Hollis, Wright, who are standing by, 844-LAW-TALK, the number to know. They are standing by right now. You want to take advantage of that, get on the phone. Just a few minutes remaining for that opportunity. Josh?
All right, so when we went to break, I wanted to get into this. A lot of times, having debt that you can't service on a monthly basis is super stressful for families.
Absolutely.
They're getting called incessantly by bill collectors and those people that are trying to collect these debts. Tell us a little bit about what does the bankruptcy do to that process? Does it help in that area?
Absolutely it does. That's a great question. When you file bankruptcy and the case is filed with the court and all your creditors are served, the first thing is what's called the automatic stay, and that's where the debt proceedings or any collection efforts against you must cease until the court has an opportunity to rule on these matters, or they file claims with the trustee and different things. So yeah, once you file, I always tell people it's like the party in the Red Sea. Is as soon as you file, 2 or 3 days later, you're getting 50 phone calls a day. It goes to zero. So, and that peace of mind is worth a lot.
Yeah. Well, not just the peace of mind of that, it's the peace of mind of having a lawyer on your side that is able to help manage through that process and kind of lead, guide, and direct you. Here's a question I know a lot of times we'll get when we do a show related to bankruptcy. How does someone pay their bankruptcy lawyer? Is it paid through the bankruptcy? Do they pay directly to the bankruptcy lawyer? Because a lot of times people think, well, I can't afford a lawyer to even get bankruptcy started.
Sure.
That may not always be the case, though.
Absolutely. That's one of the benefits of a Chapter 13 bankruptcy, is, you make a monthly payment to service these debts, and that is part of what pays your attorney. So, if people think, well, gee, I can't pay my debts now, how am I going to come up with extra money to hire a lawyer? Like you said, you don't always have to.
Yeah. And that's a good question. I mean, you take free consultations when people call you about that stuff to be able to help lead, guide, and direct them through it.
I'm glad to do it anytime.
Question we've got here, are there any debts that I cannot discharge?
There are a couple of debts that you can't discharge. As you've always heard the old saying, is the only two sure things in life are death and taxes.
Oh, Lord.
So, if you owe the government, you can't discharge it. You can't discharge, criminal fines if unfortunately, if you had a DUI or some kind of drug arrest years ago, or those things you can't discharge. And some specific other things, technical child support is another big one. You can't discharge that. But you can use a Chapter 13 to pay these things back in a manner that's reasonable under your budget and well structured, because you can, with the IRS or child support, you can end up in jail in some of those situations. Right. So, but the bankruptcy court can help you with that.
Yeah, and I was going to ask you that. Will the bankruptcy? Let's assume someone owes child support, and they may even be in arrears with child support. When you file, does the bankruptcy court not take over the child support, but can they help structure a payment?
Absolutely. That's a great question. They sure can. If you have an arrears amount, let's say you were behind $3,000, and you filed a Chapter 13 bankruptcy, which is a debt reorganization plan where you pay a payment that covers your secured debts, and part of it goes to your unsecured creditors as is available. Part of that would go to pay your child support, and then as long as you took care of your obligations in bankruptcy, it would catch up your arrears in your child support case.
I know another issue too is, hey, back in 1983, I unfortunately had to file Chapter 7. I'm struggling right now. This is a really tough time. Can I file Chapter 7 again? How does that work?
That's a good question. You have 8 years in between filings. You can't file a Chapter 7 for 8 years from the time you file the first one. So if you've had, hardships in the last couple of years, as a lot of people unfortunately have and unfortunately will in the coming year, absolutely you can file again.
Is it accurate? Chapter 7, I look at it as a full liquidation, whereas a Chapter 13 is more of a restructuring. Is that a fair way to look at it?
That's a very fair way to look at it. Absolutely is. Like I said, in a Chapter 7 is under what the bankruptcy code calls the best interest of the creditors test. What that really means is, hey guys, even if I sell everything I have with my exemption levels, you're not going to get any money, so I'm unable to pay this back. And it gives you a fresh start, wipes away those debts, and you
How
can rebuild.
early should someone get in touch with you? Because I've had friends who've gone through this, and usually they can see it coming and it doesn't look good. And I mean, should you wait until the wolf is at the door, or a little earlier the better?
Well, the earlier the better. Like I said,
Even if it's a consultation, hey, this is the way things are looking.
Consultation, yeah, sure. Take 30 minutes or an hour, and we can discuss your situation and maybe give you some alternatives, as you said, in more of a counseling role to things you can do. But I wouldn't wait too late, because if you're facing repossessions and foreclosures, can you save your property? Sure. Not if it's already been foreclosed on, unfortunately. Not if your car's already been repossessed.
Right.
That's too late. Yeah. So it never hurts. It's a free consultation. We're glad to talk to you to give you some good advice for those times.
Yeah. Do you handle in your practice foreclosures? I know it's off topic, but I was just going to ask. I don't know if you do any of that or not.
Occasionally we do.
Okay.
Occasionally we do. We handle foreclosures. There's one bank that does it. I have one client that does it. They don't keep a lot of loans, so occasionally we handle a foreclosure. So.
Well, the biggest asset, and the reason I was even going to mention that is the biggest asset a lot of people will have is going to be their home. And
correct.
If you wait until it's too late because your home has already been foreclosed, that can negatively impact your bankruptcy, can it not?
Absolutely it can,
Okay.
because if your house has already been foreclosed on, once the foreclosure process is complete, it's not your property anymore. Yeah. Even if the foreclosure was scheduled for 5 p.m. today and we can able to file a case for you prior to that 5 p.m. deadline for the foreclosure, then that would kick in, as we talked about, the automatic stay. Yeah. They couldn't do the foreclosure. And I've had that happen to where, there was a foreclosure sale scheduled for 3 o'clock. We file, they show up for the sale, and we take them a copy of the petition. They're like, okay, sale's off.
Yeah, so this is another reason why having someone that can counsel you through the process, if you run into these types of circumstances, you want to have someone like Josh on your side that you can contact and get good advice, because he can counsel you on how to get yourself out of this problem, or the answer may be, hey, look, you are at that moment, you are at that doorstep, it's now time for us to get some things filed to help protect you.
Yeah, we talk about this quite a bit, but this is one of those areas, I think, personal finances, where folks they just bury their head in the sand, hoping it'll go away, and it never goes away, so things just get worse.
When we come back, because I know we're getting ready to go to break, I do want to talk a little bit about garnishments. Lots of people across our state have garnishments where their check is garnished per month, and whether or not that is going to be impacted by a bankruptcy, or whether a bankruptcy can create that garnishment. I want to talk a little bit about that.
All right, we're stepping aside. Our final break of the evening. As we do so, Hollis Wright is a fantastic follow on social media, wherever you are, Facebook, Twitter, YouTube, Instagram. The firm is there as well. A great informational, educational follow. Stay tuned. The final segment of The Attorneys is coming right up.
I'm Josh Wright with the law firm of Hollis Wright. In court, Attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 4-in-1, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Now, Rule 403 of the Alabama Rules of Evidence states, in part, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule and is to be excluded. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is wealthy or rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there's sufficient insurance coverage or assets to satisfy a verdict. Most likely, the parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during trial, there likely are resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. And as always, thanks for watching The Attorneys right here on WDTN 13.
Welcome back into The Attorneys. About 6 minutes remaining in our show. What that should trigger in you, 844 Law Talk, because if you want to speak with an attorney from Hollis Wright, about 6 minutes remaining to do so. Josh?
All right, let's talk a little bit about garnishments. I want to talk about two scenarios. Scenario number one is I have filed bankruptcy. Can my check with my employer be garnished? Issue one is there.
Okay.
So how do you answer that?
Well, once you file bankruptcy, back to the automatic stay, the garnishments would stop. If you've been sued and your creditor has a judgment against you and they've garnished your pay, the garnishment would stop upon filing. And just because they filed or started to garnish your check doesn't mean you still are not eligible for bankruptcy.
Okay. And can you be garnished in your check through the bankruptcy? Let's assume, for example, you owed a certain amount of money in your bankruptcy. Can they garnish your check? And if so, is that common?
It's more of a convenience thing.
Okay.
If you file a Chapter 13, you can do a withholding where the trustee withholds that, comes directly out of your check. But the benefit of that is things like the arrears on your mortgage, your car payment, maybe you bought some furniture, those things, all of those things are paid from that, so you don't have to make additional payments on top of that.
Can I ask a question? I know I didn't mean to jump on you.
No, it's your show,
I did want to ask this though. Have you seen during kind of the crazy coronavirus that has lingered for a period of time, have you seen that creditors are more willing to work with folks than they have been in the past?
I think they are. I think it's different for every creditor. I think some of them are, and I think there is, in the news there's been orders by the governor and orders by our Supreme Court about things where some collection proceedings were slowed. Filings have been, in talking to the bankruptcy clerks and judges in this district, filings have been lower this year, but they do expect for them to increase because, unfortunately, a lot of these folks that are struggling through these hard times, your creditors probably won't always be so forgiving.
Yeah. Take advantage of it while you can. You brought up, Josh, the term trustee. Got a question here about it. Does the court establish the trustee, and kind of how does that work?
Yes, the bankruptcy trustee is there to make sure that your case is administered, fairly, and to review your plan to make sure that you've listed your assets correctly, that you're not hiding things. that you're not abusing the process, but also to make sure that it's fair to you and your creditors, that your creditors are not, filing frivolous claims in those things. The trustee, I guess you could say the trustee kind of administers the process.
And a question that we have gotten before is, if I have cash on the side and I go bury that cash, not literally but figuratively, do I have to report that on my bankruptcy? The reality is you're swearing under oath when you submit a bankruptcy petition that these are all your assets. If the court catches you not telling the truth, you can have some major issues, can't you? You
can have serious complications from that. At the end of your petition, it says that I swear under penalty of perjury that these are correct, and lying on a bankruptcy petition or withholding assets for the purpose of not paying your creditors, that's a federal crime.
Real quickly, one final question I had for you before we get to kind of our final thoughts is, as it relates to your bankruptcy, do you have to file bankruptcy on every asset you have? Like, do I have to do it on my house, have to do it on my car, or can you pick and choose what you want?
In a Chapter 7, you absolutely can. It's a great question. As people say, well, I don't want to file on this creditor or that creditor. You have to notice all the creditors. You have to list all of your creditors and all of your assets like we discussed. But if you had 2 cars or 3 cars and you said, this is just too much, I've gotten it over my head, I can't pay for all these, I'm just going to keep this one. You can do that and reaffirm that debt and not file on it.
A minute and a half remaining, time enough for a final thought. Josh O., if you would, you go first, please, sir.
Well, it's glad to be here today with you guys, and this is a trying financial time for a lot of folks, and don't hesitate to reach out to an experienced bankruptcy attorney or myself or my firm. Would always be glad to speak with you to give you some advice to help you in a very uncertain time.
Yeah. And this is one of those circumstances, David, where you don't want to go it alone. You want to have someone that is experienced. The word he used was an experienced bankruptcy lawyer, and that's probably just common for him to use that term. Right. But that term means something, and what it means is that you want to go to someone who learned this area of the law and is good at it and can help counsel you through this process. And so going to an experienced bankruptcy lawyer is critically important if you find yourself in trouble. Don't wait until the wolf's on the door, as you were mentioning. Try and get to it earlier. And if you forget Josh O'Neill's name, contact us and we'll get you to Josh O'Neill. So all they got to do is come to us every Sunday and we're going to get them over to Josh and be happy to help.
844-LAW-TALK.
That's it. That's it. Good job today. You did a really nice job.
Thank you to the both Joshes, and thank you as well for joining us. We, as we say often, and we really do mean it, almost 500 shows now. We're really grateful that you join us here each and every Sunday night, and we'll look forward to seeing you next time right here on The Attorneys. Have a great week, everybody.
Thanks for watching The Attorneys, sponsored by Hollis Wright.